I'm Michael Veal. I'm an associate professor at University College London, and I'm really happy to be here moderating what is, I hope, going to be a very exciting panel, well, I'm pretty sure it will be, around enforcement, looking at enforcement through a comparative lens, looking both backwards at the GDPR, forwards at the GDPR, and also forwards to the AI Act, and looking at what we can learn from the space of regulation on the paper and in practice here. And there are 4 people on this panel who I am excited to hear from each one of them. The broad background is that enforcement has indeed been the subject of many questions, not least the wonderful workshop run by Wojciech, who's just arrived in the front row, previously a couple of years ago, and it's becoming a big and heavy topic as the digital single market and the associated sort of digital acquis becomes more complicated, maybe more overlapping, with more actors involved, a lot more boards. I mean, there's the number of boards is growing exponentially like rabbits, but they all do slightly different things. They all have slightly different roles, and we've seen a variety of new proposals, some of them to consolidate this, which we'll be talking about, I'm sure, and to think about how these work in practice. Discussions of how the European level of law clash or interact with administrative law and administrative structures at national level, questions about how this practically plays out in constrained resource environments or environments of increasing, or maybe never ever got to grips with, technical complexity. And to do that, we're going to wind through from different perspectives in a conversation about this and then open it up. With me, I have Eva Lackniet. Eva Lackniet is the Deputy Head of International Policy and Transfers at the Autoriteit Persoonsgegevens, which is the Dutch Data Protection Authority. I have Karolina Mosnesiewicz, and she is the Deputy Head of Unit at the Unit responsible for Data Protection at the European Commission in DG Just. I have René Mathieu, and he's an Assistant Professor in Data Protection and Privacy Law at the Open University in the Netherlands. And I have Kai Zenner, who is the Head of Office and Digital Policy Advisor for MEP Axel Voss, and anyone following the AI Act knows that Kai Zenner put himself in the information vacuum bravely and boldly, and was much appreciated for doing so. I think we're going to not start with sort of opening remarks and say we're constructing a conversation and build it up in layers, but as you'll see, we'll have plenty of opportunity for both the panelists to give you their layered experiences and bring in the area of expertise, and I think demonstrate through their words why they are at the table here. Firstly, I wanted to ask the panelists to reflect on, we're talking about enforcement being difficult, and I want to think about why this is difficult. What kind of, from the perspectives that you've worked on, why have you thought enforcement is tricky? What challenges have you faced or dealt with when either drafting legislation or implementing legislation or thinking about new legislative proposals and similar? What flavor of challenges are on the ground? And maybe we can touch on some unexpected ones that people might not think are real barriers, contrary to conventional wisdom. Maybe I'll start with René, actually, if that's okay, just to reflect on this, and we'll go across.
That's okay for me, although I cannot promise in this case that I'll come with something really eye-shattering new.
And one thing I'd quickly add is that this can be enforcement across instruments. We're talking GDPR and AI Act in a bit of a mixed way here, and we're deliberately doing that to kind of cross-fertilize and learn from the two spaces, and that's why the panelists are assembled.
Yes. Thank you, Michael, for the introduction. So for me, I think the first question, or what makes enforcement hard, in many cases, and especially in the GDPR case, is that exactly that's what it tries to legislate is the thing that is at the core of a lot of business models. And this is, of course, a very known issue, or it has become very prominent in the discussions about the GDPR. It is very much less known, I think, in a lot of other fields, and I think that's a question that needs to be more opened up in the regulatory space, because even though it's true that we're all talking about it, or at least academics are, and in the pub maybe we are, I still think that at the level of the authorities, the question has not been grappled with enough. So when is this the case, and how do we respond? How do we respond to that? I think that is not only the case with authorities themselves, but really at the political level. You have this clash of you want to protect something, some fundamental rights or safety, security, but you also want to protect an open and prospering economy. And then choices have to be made. And I think what we often see is the political level doesn't really dare to make the actual choices that I think should be made democratically. And then authorities have to somehow make up their minds, somehow solve this. While that is, I think, shouldn't really be their role, although I think it's heroic, and they should, given that they are now given that role, they should actually take up the role, because it needs to be done.
Okay, so the passing of difficult, value-laden questions, kicking the can down. Yeah. So, as the hero ever in this story, let's hear from you on some of the tricky enforcement factors that you.
Yeah. So I fear that my contribution was going to be a little more operative, as I am from the Data Protection Authority, and I've spoken with colleagues a lot about what they come across as problems in their enforcement. And speaking to the investigative department and the enforcement department, the first thing that everyone said was the difficulty to enforce open norms, to fill that in according to the case at hand, to come up with an evidentiary threshold that will hold up in court, and to come up with a solid case to present if you're ready to enforce. And the more open the norms are, and in the case of the GDPR, the more it is applied to different actors, because as we know, GDPR applies to very small companies, but also very large ones. It is a challenge each and every time, and you have to reinvent the wheel as you go. So from an operational standpoint, that was, I think, the most difficult thing. For me personally, because I am involved in cross-border enforcement, I work in the enforcement subgroup of the EDPB, I work with a lot of different enforcement cultures, and the problem that we encounter is the difference in national administrative laws. And I'm sure that Carolina will touch upon that as well. But that is something that is very difficult to work with, because you have this beautifully harmonized substantive rule set in the GDPR, but you don't have this in procedural law, at least not to the extent that we would want to. And if you have a real-life case and you want to apply it, you're bound by the rules of your national authority, which means that in some countries they can publish about cases, in others they cannot. In some countries they share information, and in others they do not. And these are just the procedural rules that we're talking about. When we're working together to enforce a system as the GDPR, you also are faced with cultural differences. So SAs, supervisory authorities that are really good at prioritizing and are really strategic in the way that they choose cases to focus on, whereas others are maybe more formalistic and have other values that they place at their core. So those differences makes for a very interesting playing field.
Great. Thank you. Thanks, everyone. So we see some different fault lines emerging, particularly with the international nature of everything. Kai, as a policy, either a policymaker or close enough to policy, I'm not an advisor in the policymaking world, how have you seen enforcement play out in maybe a more prospective way, I guess?
Yeah, exactly. So I can maybe complement a little bit and talk about concerns that we very much had in the AI-act negotiations, and we actually wanted to learn a lot from certain things that maybe were here and there a bit problematic, not working in GDPR and in other fields. Where we are now that you saw it that the council now finally also gave the okay. We were in this kind of constant new episodes of now we have a deal, but very soon the AI Act is really entering into force. And right now, many political groups in the parliament would, I think, say 4 things we are very worried about when it comes to enforcement, and that we maybe haven't really learned from past mistakes. And this is, first of all, the lack of secondary legislation, also the slow progress and process in bringing forward the secondary legislation. You all saw probably by now the text in the AI Act. It's very vague in many areas intentionally, because we wanted to go more in a principle-based direction. But in order to fully understand what is AI, you probably need a little bit more than the recital and the small sentence that is very close to the OECD in Article 3. So already there, we are all waiting for guidelines, and it's completely unclear when they are coming, if they are really giving every detail that we want to know, and so on. This is, of course, giving member states also a huge opportunity. What we are hearing right now from Spain is that they are working already on detailed summary when it comes to copyright protected content, and maybe then they could present this for the European level as a kind of best practice, and it's then taken over. But again, in the next months, I would say there's a huge question mark. We could see again, you asked me now about certain concerns, we could see again very much fragmentation because of this lack of secondary legislation, but also because of the fact that the European AI Act is leaving it to the member state which national competent authorities they are assigning for the AI Act. And it could be that, for example, in France, it will be the data protection authorities that are, of course, independent. In Germany, it seems to be the Bundesnetzagentur. Others will take cybersecurity and so on. So we will have very, very different national, but also content-wise perspectives on AI. Some of those bodies are independent. Their union safeguard mechanism from the Commission, which is trying to streamline the different interpretations, will not work because those independent bodies will say, screw you, Commission, I don't want to listen. So also this is a big thing. And in general, the AI Act, and there I think actually the GDPR was easier to fulfill and to enforce. The AI Act is extremely horizontal and is covering basically all different sectors, and those sectors have already a lot of legislation but also a lot of enforcement bodies. And now all those different actors need to learn to speak together about the same thing. We also have this problem that now, or not problem, but this fact that fundamental rights protection is being included in product safety legislation, which so far only knew about how to protect health and safety. And now they need to talk with data protection authorities, for example. And we just don't have lines of communication so far. So in general, I think our big fear is it will take a lot of time until this AI governance system is up to power and up to, can be active. And then, of course, the final points that we are all afraid about, again, I'm looking in the future, is the lack of funding and also the lack of talent. Imagine a Bulgarian data protection authority that is already telling us now for many, many months and years that they are underfunded, that they don't have sometimes enough money for new computers and so on. Probably as a means to save money, they will be assigned as National Competent Authority also for the AI Act. How are they doing both, basically? And how are they attracting, or Malta and a lot, even Germany and the Commission now with the AI office, they all are in competition with large companies that are probably paying much more money. And if in the end, the AI office and the national competent authorities do not find enough highly qualified people, how do they engage with stakeholders? So this maybe is a kind of umbrella of different problems that we see.
No, certainly, like very daunting problems. Definitely, they perhaps they put the GDPR problems make them pale, but maybe not. So I think let those settle in your mind. Those variety of the panoply problems. We'll move to Carolina. Carolina, the first two words of the regulation that you've been so pivotal in proposing are effective enforcement in the memo, at least. So can you say that what follows is going to deal with the problems you've diagnosed? What are the tricky areas that sort of drew you when you were drafting and writing and researching?
The
and everything?
procedural regulation, you mean?
Yes, of course. Yeah, the procedural regulation
yeah.
on harmonization. So
well,
you can leave Carolina to talk about this.
What it was, I think we wanted to tackle actually three main points, and it was fostering or forcing out very clear and taking ownership engagement from the lead and concerned authorities, all the DPAs, while working on the cases as early as possible. So it was one thing. In order to decrease amount of dispute resolutions and so on. So really clear responsible cooperation, not kicking comments and not engaging with others down the road, 1. 2, it's clarifying and harmonizing across the EU the position of the complainant, where we have very big differences between the member states. And 3, clarifying and harmonizing the due process rights for the controllers, processors, parties under investigation. And all of this in order, because your main question was what are the problems and how we are setting up really the enforcement, what do we consider when we are legislating on the enforcement? Well, we always bear in mind, of course, in the era of GDPR, it's the question of how to set up a truly independent authority. To a big extent, we had a very clear guidelines from the court already. GDPR has it all in. With what equip it so that it can really effectively work, and not only from the point of view of human and financial resources, but from the point of view of powers. Which powers do we really need? And then in the area of the GDPR, when the decision was taken about this decentralized system of enforcement, it's how to provide for the cooperation between the authorities and how to ensure consistent interpretation and consistent enforcement. And this is where our procedural regulation comes in at this moment, because everything else, what we consider important from the point of view of setting up an enforcement mechanism, was already tackled in the GDPR. Generally, when we are, and this we took also into account while drafting the procedural regulation, we were of course also thinking about 3 elements which which every enforcer pursues. It's or deals with scarce resources, because as much as we provide for sufficient resources, enforcers will always have scarce resources. Public administration, there are scarce resources everywhere, right? Then ensuring of pursuance of public interest objective in all this, right? And then how to set up a system which, in particular, when we have enforcements ex post, de facto, we do not have the approvals before, we ensure strong decisions, deterrence. It means decisions which will be coming out will be standing in the court. And this, again, informs some elements which we took up in the procedural regulation. Therefore, harmonization, for example, of the due process rights position of the complainant, right? So, which also fits into how the authorities should cooperate. So it's all actually very much interconnected.
These are difficult ecosystems to figure out, and I think that's one thing we know about effective enforcement is there's no silver bullet that we can just turn to. It's a whole array of disciplines and approaches. One of them that we've seen is this phenomenon, maybe it's a phenomenon, I don't know, of European level enforcement across the whole digital single market regulation, particularly on cross-border areas. More forms of enforcement or cooperation or coordination in different parts of the new pieces of legislation that have been proposed. And the EDPB is, of course, sort of the main new innovation in the digital regulation world. It's the body of the union. It has actual powers given to it, and it has roles that it plays very formally compared to other coordination mechanisms in other pieces of legislation. Now, we know what these roles are on paper. You know, we can read the GDPR, and we can say, okay, the EDPB should do this, and it should vote in these situations, and so on. What I want to get from this panel here, who have the secret, see some of them behind-the-scenes knowledge, I'll start with you, Ella, is in practice, you know, what's the differences between EDPB, you know, on paper and in practice? What are all of the secrets of what happens here in these meetings? But moreover, I guess, you know, what's the kind of role? Is it how does the APE see the EDPB? You know, what's the, you pass things on that are very difficult? Do you pass things on that need political support? Do you pass things on? And what do you see other agencies doing, the role it plays sort of in the real world?
In the real world, as far as you can call a supervisory authority the real world. Well, I can talk a bit about how we see the EDPB. So to keep it personal and not give away too many backstage secrets of the EDPB itself. Perhaps. But the Dutch DPA really sees the EDPB in two ways. It can be a platform for exchange on the one hand, and it's a hub for harmonization. And I know that this is in the GDPR, but if we look at a platform, for us, we really use it to meet our colleagues, try to reach consensus, and use the meeting rooms and more the coffee meetings that we have in addition to the meeting rooms as a way to try and reach compromises on cases, to come to a better understanding of each other, and to really make sure that we make use of this network, of this ability to see each other every month to help enforcement along. So that's one very informal function of the EDPB that we try to use, and we use that across the board, so in all different subgroups and in all different subjects. As a hub for harmonization, we very much contribute to the guidelines of the EDPB. We'll talk about that in a bit, I think, as well. Because we think it's very important to create a common understanding of the principles in the GDPR. And if we cannot reach it by guidelines, we want to create that understanding by using binding decisions or by asking for opinions, as we recently did. And we have pushed for the EDPB to develop itself in that way, and I think we can all be very proud of how we have developed this in the past 6 years, more or less. And that's very much thanks to the Secretariat and to everyone that takes part in it. But having said that, the Dutch SA really also believes that the EDPB should be agenda setting and really try to engage in the conversation beforehand, particularly when we're talking about all these new developments and new technologies and new regulations that are coming up. So we very much welcome the seat that the EDPB has, for instance, in the high-level group on the DMA. And we think that that kind of cooperation and having those conversations with other regulators up front is very important and something that has to be developed more and explored more in the future.
It's nice to see those informal connections trying to weave together some of this European legislation that people are so worried will overlap and cause some chaos in practice. So it's nice to see those institutional mechanisms. Maybe other members of the panel want to come in on the role of these sort of shared and collective bodies and fora, both in practice and on paper. And I want to just invite who has thoughts on that. Otherwise, we can.
Well, I mean, we are receiving now a lot of, because the Commission is due to publish a report on the application of the GDPR by in this year, which we will do end of June, beginning of July, and we are receiving a lot of input. And we are receiving also, we will a study from Fundamental Rights Agency, which engaged with a lot of DPAs evaluating, or getting their input as how they see the work and this achievement of the consistency. Well, I'm not sure this, if we can give, if the outcome of this study is as positive as ensuring of this very consistent interpretation and enforcement of the GDPR is concerned. I think that a lot of complainants, not I think, we are receiving a lot of comments from the complainants, the outcome of the public consultation is the fragmentation in the EU, and the fragmentation which is not stemming so much from the ability of the member states to still adopt laws specifying the GDPR in specific areas, but although the EDPB exists already for several years and produces a lot of guidelines and so on, fragmentation in the enforcement and fragmentation based both on individual decision-making and on the national guidelines. So I think there is a room of improvement. Indeed, of course, we are now going back to what Eva said, looking into and reflecting how to foster cooperation between variety of enforcers across the instrument in the digital agenda. This is very interesting, but indeed, maybe let's start with the consistent enforcement of the GDPR already, yeah, and a little bit, indeed, therefore the procedural regulation, a more expedited dealing with certain cases and so on. So yes, we are very much aware of this to 2 points. So cooperation between the enforcement and the need to ensure really consistent interpretation and application of the GDPR also in individual cases on the national levels.
Renee wants to come in as well.
Yeah, well, I think this is a very important point, especially the fact that there are still huge differences in interpretation, and that is a consequence of choosing like open norms. And I think it is, but I think there is a kind of a very big, like, how do you call it, like internal inconsistency in, on the one hand, wanting a board like EDPB or the DPAs to kind of find a consistency while also allowing member states or having this structure within the EU where enforcement is to a large extent, member states are allowed to have their own system as long as they uphold some very general principles. And as long as those very general principles, such as effectiveness or dissuasiveness, are allowed to remain very general and don't get filled in a more particular or precise way, you will, I think, have this kind of differences persisting. Unless, and that is maybe for the following topic, you might try to write guidelines on administrative enforcement, where you try to find together a collective way of interpreting that. But I think it remains to be seen the extent to which the EDPB is kind of allowed to take up that role. I hope it will, because if it doesn't, I don't see who else would do it.
And I think this links a lot to, say, recent work by Ola Linsky on exit valves for some of the tensions in data protection, or like it's very wide scope. You have all these discretionary choices that have to be made about what strategy of enforcement you take in order to deal with the sheer breadth of the regulation that can be up to there. I want to move on, but bring Kai in while doing that. Thinking about what else happens at these central levels and the role, particularly as we imagine these central coordinating levels of producing guidance, guidelines, information on the coordination, which is particularly strong or hoped for in the AI-Act, both through some of the work of the office and then some of the work of harmonized standards bodies and similar, and their sort of coordinating role. But please feel free to come on the previous point as well.
Yeah, maybe just really shortly, because we had really lengthy discussions in the trialogue, but also in our parliamentarian pre-talks about those questions. We were always looking to what happened in the GDPR, but also in other parts, and actually DSA, DMA, were also a big shift, let's say, in the approach and also in the acceptance of let's have cross-border cases really being dealt with on a European level. I would say there is now, it's the kind of the common line, and it's really going back to what I said already, that especially smaller member states didn't really feel capable of dealing now with Microsoft case or with other cases. And of course, nowadays, digital doesn't know borders is a sentence that we always hear, which is, however, true, and therefore you basically do not find very often a case that is really just happening in one country. And what we, however, also saw that there was still this national pride. I will not name now countries, but some of them that were saying, no, we have our own AI agency, at least we are planning to have it, and therefore we are not really interested in an AI office, in an AI board, and so on. And even in the negotiations, those member states were already threatening to not contribute with the funding, not contribute via information, which is then kind of weakening this new mechanism from the beginning. In the end, as I said, the common line was to have some kind of centralization, to try out now this combination of AI board and AI office, and checking a little bit how it's cooperating also with existing bodies. Brügel and I made this overview of, I think now it's 69 enforcement bodies for digital files, and it will be probably very problematic, and therefore maybe to close this question a little bit, as you saw now in the discussions of the Council for the next mandate, and the same is also happening in the European Parliament. There is a lot of talk talk how to how to advance this cooperation. If we are, for example, kind of copy-pasting a model from the Netherlands, from Ireland, from the UK, where you have this digital regulation coordination forum, which is bringing together ICO, CMA, FCA and Ofcom, I think, in the UK, and is kind of a platform where then in the future EDPB, ENISA and so on could talk with each other, or if we really need a future digital enforcement agency like some D9 countries are proposing. I think this is a really interesting question, and it's very, very closely to the new MFF in 28, because for all those ideas, we need new funding. And probably until then, we also see with all those new enforcement bodies that were now introduced, if it's already working, or if it's not working, then really let's take this new budget and do something even more centralized.
So on that topic, and thinking about the role of different member states here, we find the big decentralization of informational systems and the positioning of this across borders. Very interesting there are the guidelines from the EDPB recently on main establishment, the notion of that, and indicating that we might have to be a bit tighter and make sure that the actual decisions are being taken in the place which claims to be the main establishment, else you can just, we might find a lot of companies putting a plaque in Malta at some point. And I wonder we would find this, companies doing a plaque for the AI-act here, just because of the size and because of the enforcement capacity and the natural limits and the size of some member states compared to others. And this, I think, shows a couple of things. It shows the importance of that kind of coordination and these mechanisms to distribute across the union. But it also shows the importance of guidelines in reacting and using the powers that are available to use the tools to say, okay, actually, we can deal with some of these issues of arbitrage, and we can work on that. And the EDPB has done that. And I wonder whether we find other roles of this shared guidance as well. There's a lot of emphasis on guidelines. Do you think that they've worked at the moment? Do you think as they function, they could do more? They could be specific. They've been difficult points of contestation. What's the sort of social role that these play in regulators? And should we pay more attention to that? And how might that happen in the AI Act as well? I don't know who wants to come in first on this. I know Eva had thoughts on guidelines.
Well, maybe I can come with a simple point, because I think it's very easy to criticize guidelines, and I think with all the ones that I've read, there are points that I can criticize. But overall, I think they're doing very well. And I also think it seems to me from the outside a bit that they have an extra function, that many DPAs are sending their bright people there. So it's an extra, it can be quite technocratic group of people that works on something. And I think people, although authorities are supposed to be really independent, there are what I would at least call political questions at play within national DPAs. And I think in that sense, the EDPB can also be kind of safe space where actual decisions can be made. And more like these open norms can also become more concrete. I think the big open question here, the main big open question that I have is how are courts going to see those guidelines? I see that at the European level, I feel there's quite a lot of respect for the EDPB, and I think that's good, because on the one hand, a guideline is not a delegated act, so it is not the law, but it should be, and I think it often is, the best kind of collective agreement that people who really know their field come to. And I think there should be quite a deference to it. And I think as long as that is the case, they can play a very important role. And they are, I think, playing a very important role. However, on administrative fines, there I hope that it will be the same, but I'm not very confident, because the gap, like the GDPR, basically put huge maximum fines and a very open system of how and when to apply them. Someone needed to step in. I think there is now been someone to step in, the EDPB, but we'll have to see if the courts will accept that as a basic structure to now move forward.
It's very tempting to react specifically to that last point. Yeah, I can tell. But for the sake of what this panel was about and better enforcement, maybe we shouldn't focus on defining guidelines in particular, although they are a good example of what a compromise looks like and what informal cooperation towards a certain goal looks like. So in that sense, I'm proud of the guidelines as they are. But I wanted to highlight a slightly different point, actually, that also connects to the discussion that we had before. And that is the fact that the way that enforcement of the GDPR is set up is also chosen because we want to bring the GDPR to the data subjects. It's not just about single market regulation, it's also about fundamental rights protection and having you as a data subject being able to go to the supervisory authority of your country, file a complaint, be assisted in your own language and having you being guided through that process. That is something that is central to the GDPR, in my opinion, and central to our work as a supervisory authority. Then coming to the point of guidelines, it is true they are very legal technical, difficult to read at times, and in that sense I wanted to highlight also the pledge that the EDPB has made in its strategy to make it more accessible and to tailor guidelines better to the general public, to tailor it to SMEs or to children, and I think that is very important. And that is what, in my opinion, the function of guidelines is: giving information, making the law clear for different groups that need that information.
I look forward to children on the EDPB website, logging in, checking out the consistency mechanism. But no, the point is very well taken. Please share guidance and guidelines.
Well, for us, indeed, guidelines, we were very much supporting guidelines because GDPR is so much principle-based that the guidelines are putting really the flesh on the bones. But let's not forget, these are interpretative instruments, and there the question is, are they sufficiently representative from the point of view of all the DPAs? And are the DPAs really willing to apply them on the national level? And here I'm coming back to the point I made already before. Well, not always the case, because we already have not only not application of the guidelines in individual cases, but diverging guidelines, national guidelines, right? This is a big problem because then there is one wave with one interpretation, sometimes very far-reaching in the EDPB guidelines. There is, so the market is already reacting and stakeholders are coming to the Commission to complain or not, or to say that this is precisely what should happen. And there are another waves saying like, well, so actually, what of all of this will happen, right? What was said or what our DPA is telling me on the national level. So this is, from our point of view, a little bit the problem we see. And again, as with a lot of things, there's ownership, so that when something is agreed, that it is really consistently applied by all the DPAs, because this is the tool to achieve the consistent interpretation of the GDPR and enforcement, and that it can then quickly be tested by the courts, because guidelines are such a not attackable acts, and they need to be really verified by ultimately Court of Justice. We, the Commission, we were always supporting very much guidelines which are really telling what Eva mentioned at the end, that they provide for the legal certainty, in particular to the SMEs who do not have the resources to get very extensive legal advice, and which further, looking a little bit further, this is the mantra which is being repeated very often, is that the GDPR is so difficult to work with because it's so principle-based, because it's so difficult to understand, and therefore it's such a huge burden. So actually, if the guidelines are very much clear and telling, the burden, it's automatically diminished, right? And it's made clear. So for us, it's also like policy-wise a very important, let me call it even shield against the arguments that GDPR is so much fomenting costs for the SMEs, right? And here, another very important element, guidelines on the level of the EDPB require engagement also with the stakeholders. And this is something that for the Commission is very important. They need to, this engagement with the stakeholders needs to be also mirrored in the guidelines. And it's also here the whole discussion whether more guidelines, more opinions, one opinions, and on what opinions, if they do not allow for inclusion of the engagement with the stakeholders when we have a very important societal decisions to take. So, yeah.
I think there's an interesting, when we think of diverging national guidelines, point around national courts, which, of course, if it's not the final court, and you do not have to refer to the CJEU, but then you do get divergence in the national court system, and then the interaction between the regulators and the valid, legally enforceable national court decisions, and how that relates when the divergence has not been passed up yet. It's very, there's definitely a lot of landscape which is quite deep. Kai.
Yes, I'm quite comfortable in being the fourth one, because then I can always compliment and show a little bit how policymakers, especially in the parliament, really wanted to learn a little bit from what happened in the past. As I said already, yes, we also wanted to do the AI Act principle-based. Again, in the end, it became maybe a little bit too vague, but without secondary legislation, it's definitely not working. On the other hand, we wanted to be future-proof, maybe even a bit more future-proof than the GDPR, and we saw that with this strong focus on secondary legislation, this is basically the only chance to keep up with especially such a dynamic field than AI. And this is why you see an extra article that is giving the Commission / the AI office all this power. We wanted to avoid a situation where in the future you have a Spanish guideline on what is fairness in data sets, a German one, and so on and so on. The big problem is, as you all know, the AI office at the moment has around 6 to 8 people that are working on content. They are hiring, but the hiring process takes forever in the European Commission. They are completely underfunded and so on. So there is a huge question mark if the European Commission / AI office can deliver in time. On standardization, I think most people here heard it, that even though Sebastian Heinzleben and others are fighting like lions, it's not, well, not all subgroups are up for the task and will stick to the deadline. So probably also the harmonized standards will be way too late, or at least this is a big issue. And because I'm here for the whole parliament, many groups, and even in the EPP, there were quite a lot of players that were concerned that this big focus on secondary legislation is not really in line with democracy, because let's go again to standards. Are we feeling really comfortable with this situation that it's standardized what fair is, or is it not more a political question that should be decided by the co-legislators? And in the end, we made this decision for, yes, secondary legislation, and yes, we are trusting the Commission to find a balanced way. But what we included, and this is a safeguard that also has a big question mark over it, was this advisory forum, which is basically including a lot of stakeholders from civil society, academics like you, to hardcore industrialists, players or representatives, and they basically should consult the European Commission / AI office in all those drafting of templates, guidelines, and so on. But here, again, we saw it with the AI Alliance that was coming together with the high-level expert group on AI, which is basically, well, completely worthless, I would say, because they are meeting maybe one time a year and it's not really brought through. But yeah, it could have been something really nice. And now our hope in the parliament is that all those new structures are really used, that we included in the AI Act to address many of these problems that were mentioned.
So I think we're seeing there's this big social role, and it's kind of unclear. You can't really make laws to make institutions succeed. They are about people, and they're about connections as well, and they're about the links between, and the trust between that as well, that you pass on, and people making guidelines at levels that fall outside of EU law. And so the social areas become incredibly key. I want the audience to think of their questions now, because we're going to come to you in just a moment. So we're not quite yet, but almost to just ferment them. One last question, and please keep it all brief, because even though it's the most complex question. There's a challenge with cross-border enforcement in data protection law and in the AI Act of complex structures, controllers that are joint controllers across borders, processes across borders, joint controllers that could be joint controllers across borders if you identified them as such, but not really clear who should do that when they claim they're something different. There are controllers who may not agree to be controllers at all, but may not agree to have even had any organization or main establishment. And in the AI Act, you have many actors who all are purposing and reusing and passing on systems, and it's likely to be slippery in both ways that are similar and different. Has this created challenges of enforcement in practice? And if so, do you think the tools are available in either the GDPR or the AI Act to sufficiently deal with this kind of uncertainty across borders of status and power and business structures that can evolve to slip away from law? And I don't know who wants to come in on this. It's an open question, and then we'll come to the audience.
Oh, Michael, on the enforcement, I mean, cross-border enforcement in the GDPR, well, we try to fix what we mapped as maybe unclarities or shortcomings, let me call it. And we hope that it will take off. We are trying to address this particular elements, which from our point of view were hampering or hindering or not incentivizing the DPAs to work more effectively in individual cross-border cases together, right? So now, of course, the Commission and the legislators, I think in particular, because when you look at some of our proposals and how we set up in a variety of the proposals our powers and what the legislators did with it, of course, the legislators were very much informed by the whole situation under the GDPR and therefore provided for different roles also for the Commission in the new acts which were following. Well, DMA, it's fairly obvious, but then in the DSA in particular, right, concerning very large online platforms and search engines. I think it's also mirrored to in the AI Act. And Kai was talking already about this, this element of while addressing the element of guidelines or the topic of guidelines. I think here the legislator also expressed while setting up this new enforcement models also an idea of the need for balancing between fundamental rights also, right? And yes, cross-border enforcement in particular in this centralized setting is challenging, but so far the EU legislators are willing to keep up or to really maintain the system in the light of the advantages it brings, namely the proximity to the data subject in particular, right? And yeah, well, probably in artificial intelligence, where all this balancing between where does one need such an independent authority as the data protection authorities, it all looks a little bit differently, but I think I'll stop here.
Cool. Thank you.
Yeah, I can jump in maybe here. In the AI Act, maybe to start with, we didn't change the approach of the Commission, which was based on product safety legislation standard, that in the end, to your question, this unit or entity that is placing on the market the downstream final AI system or putting it into service should basically be the one who needs to be fully compliant, and then of course it's the member states that this company, for example, is operating in, is placing the system on the market. That should be the focus for the enforcement activities. But however, we were looking again also in the GDPR and really liked this concept and actually had, I see Max and others here, we had also feedback from civil society, from companies, that the concept behind joint controllership is not something bad. And this is why the Parliament spent a lot of time, and it was one of the reasons why we were taking maybe even too long, and we're very close to the European election, to basically transfer this concept of joint controllership in the AI Act. It was in the old Article 28 that was heavily updated, and in the end, we, at least from the Parliament, are all quite happy because it's kind of forcing all those market players that you were talking about to work together via standard contractual clauses that the Commission again needs to deliver, hopefully soon. But in the end, that then this whole burden is fairly shared basically between all of them. And maybe in the future, either the PLD or the AI Liability Directive could, of course, maybe further extend a little bit those internal liability schemes or relationships. But this was the idea exactly because of what you were saying, that we were very much aware that it would be unfair if in the end only, for example, a small SME is getting all the enforcement activities or facing them, or especially the fines, while maybe the problem, for example, a biased training data set, was happening much more upstream. Yeah.
Thanks, Kai. Anyone want to come in briefly on this, or we'll get the audience as well?
Maybe just very briefly.
Yeah.
Because the biggest issue when you look at joint controllers is the sharing of responsibilities and making clear that everyone involved knows which roles they are playing, what they are responsible for, and what the other party is responsible for. And from an enforcement perspective, in the cases that we have, that has been quite challenging to map out. So I see some issues there also in other fields.
Yeah, actually, I want to, because I actually think that as a legal concept, these things that work pretty well. And I think they do justice to the fact it is just complicated. You cannot have a very complicated world and want the law to be super simple. So I think it does track the complexity of the world the best way possible, potentially. But I do see that it creates problems at the enforcement level, but often procedurally. Like, so an enforcement agency might think, oh, we have the controller here. Oh, but there is actually a joint controller, or this controller also, we have to ask now other member states because the controller is actually, we are not so sure if the controller is actually in the Netherlands or in Belgium or somewhere else. And I think there it can also add some can slow down the process in ways that are, in essence, not actually contributing to anything positive. So I think there's a bit of a risk.
Thank you. So we'll take some questions now. They end with a question mark and they are concise. Maria, and then we'll go to Max. We'll gather
Thanks so
a lot.
much. I'm Maria Magierska from European University Institute. Thanks so much for this panel. It's very interesting to hear all insights on this topic that I think we will just keep on discussing in the next couple of years after all these acts finally come into force. So my question is perhaps a bit naive. I was wondering, what's your definition of effective enforcement, actually? Because when I was listening to the panel, I got the impression that there was a lot of focus that effective enforcement is the coherent one, the one that reaches the agreement that everyone are in line what they think, and this is a harmonious application, it's the goal. But I think enforcement is a bit more than that, than just agreeing on the same goal. I think it's also protection of the rights that sometimes will bring opposite views. So that was my first question. And the second one is, in this whole maze of the institutions, what is the place of the individual, and also maybe groups of individuals, perhaps, whether the collective approach here maybe is also needed just to help the individuals navigate the maze, not only by the authorities, which are very helpful as the DPAs, especially for the complainants, but also from the other side, if there is a way of incorporate also more collective.
Cool. Collectives.
So, thanks so much.
Pass it to Max, then we'll take a couple more.
Yes.
Gloria.
Hello, Gloria González-Fuster. I have also two questions, but they are much easier, so no worries. The first one is for the Dutch Data Protection Authority. I understand you don't represent here the EDPB, but you were mentioning that it's important to bring all this closer to data subjects. And the EDPB created this one-stop shop register for transparency, so we understand how all this is working. This has not been updated since March the 6th. It's updated like every 3 months. Does this ring a bell, that this exists? Can you, when you're mingling with people, just remind them, hey, we have to update the register for transparency? Thank you. And the second question is for Carolina. We have been discussing a bit this proposal. Can you share something about how is this proposal evolving, if it's evolving? Thank you.
Thanks a lot. A very short question. I kind of challenge half of what the board has said maybe with my question. We did a survey with 1,000 DPOs on what is efficient enforcement on their side, what helps them. We sent it to all the DPAs as well and everybody else. And I can tell you almost dead last is EDPB guidelines. So we talked most of this time now about guidelines. At least DPOs say that is not what gets my CEO to actually decide to be compliant. What is top is possible loss of reputation, fines, and compliance demands from others. So just think that I have to sell the product to someone else and they demand that I'm GDPR compliant. That apparently seems to work. So my question is, can we get more evidence-based enforcement than doing another guideline that, at least to what they say, they don't read? I read them, but apparently they don't.
Good work asking us. Ending the statement with a question. Yeah, please.
Hi, Brent from the Dutch CPA. Yeah, we have all these different kinds of legal acts now and different authorities, and we will get different kinds of boards, the European Data Protection Board, the European Board of Digital Services, the AI Board, etc. These boards would ideally work together. Where do we see this going? And very concrete, where do we see this going institutionally, and what are the challenges there?
Cool, thanks. And yeah, please keep passing. So I'm going to poke everyone about specific questions, so don't worry. We're going to. Yeah, please go. Yeah.
So Christiane from Utrecht University. So I studied 14 guidelines from DPAs and 2 guidelines from the EDPB, and I found that guidelines between DPAs contradict themselves. They have quite some few mismatches, and also I found mismatches between the guidelines from the EDPB and the DPAs alone. So is there any interest or incentive in tracing back these mismatches and therefore correcting them? Thank you.
And yeah, maybe one more hit, one more at the back there. Oh, sorry, and then we'll just take these all in a round.
Thank you for the interesting discussion. Is there something that we can learn from the US? I mean, we are talking a lot about guidelines, a lot about various authorities issuing various fines, explanations, and how you're supposed to do something. And arguably, the US is moving much faster and is taking a much stronger stance, at least on certain points. Is there something that we can learn from the FTC in the first place, but also from their collective lawsuits? I mean, it's an instrument that also exists in certain countries in Europe, but we are not using it as aggressively as we could potentially. Okay. So any thoughts on that? Okay,
thanks. So to summarize super briefly, effective enforcement, what is it? Is it protection of the rights? Individuals and groups, do they matter? Why haven't you updated the one-stop shop register? Caroline, the status of the regulation, an update on this, and evidence-based enforcement, thinking about how guidelines contradict each other in practice, but also what motivates people to and regulated entities to act. Different kinds of boards. Is it going to end up in boredom, or are we going to end in something that works? And the US, the roles. So please take what you will, and I will poke people to make sure they're answered. Caroline, do you want to?
Okay, let me start. What do we think is effective enforcement? Good decisions that stand in court. This is effective enforcement. It's when an authority says something, this is confirmed by the court. Because I agree with you, Max. This leads to CEOs respecting these decisions and the statement made by the DPAs, right? And only that. And only that. Therefore, also, I here make advertisement, our procedural regulation that we want to clean up at least all the weaknesses from the point of view of due process rights. That these decisions are not quashed because the due process rights are not enforced properly. Because there are very important things that we need to achieve. So, and effective enforcement needs to be based. And here, why I was coming and underlying the importance of the guidelines? Because when we have this idea, interpretation, standing in one decision, and it's consistent, then it will have a bigger wave throughout the EU. If it's only punctual because it's just the difference of this guy, of this, or this decision corresponds to interpretation of this national guideline, but not to another one, then we are again in square one. So actually, I think this goes together, right? In particular, since we are speaking about the same law. But I fully agree. everything turns around about decisions which stand in court and are well researched, evidence-based. I understand it's also well investigated, right? And not only alleged with big statements, but decisions with, well, I don't want to repeat myself, will stand in court. Now, where is how the Gloria, coming back to you, where we are now, the council is negotiating. I must admit, I didn't ask what is official information and what not, so I'm not 100% sure what I can say or what I can not say, but Belgian presidency is very, very committed and works towards or with the aim to adopt the general approach. As you know, the European Parliament already adopted its position, and if the Council will be ready, the trilogues will start as soon as possible. Here it depends also a bit on the European Parliament, how much time and engagement they will want to devote to it. As of September, I mean, what can I say? My bosses will change with the elections, but so far I can say that the Commission is very much committed to have this regulation advancing as soon as possible. Collective actions, we never in the EU wanted this kind of solutions. We think Article 80 addresses this point, and from our point of view, this the US approach has advantages and disadvantages, and in particular, bearing in mind the horizontal nature of the GDPR and affectance of variety of businesses of very different size, I think, well, not only in the GDPR, but the European legislator is not supporting this kind of solutions, but still matching it with the equipment of the NGOs with tools like in Article 80, for example. And I think I'll stop here.
Cool, thanks. I would note that in the EU, data protection is included in the representative action
exactly,
directive. So
exactly.
It's not quite true that we don't want
Perfect,
that solution.
Michael, thank you very much.
It is there as well. But yeah, that's it.
Yeah.
So, Kai, I would also urge you on the...
I see
it's
the
okay.
timing.
I urge you on the individual and group question,
exactly.
the board question, but other things you want to tackle would be good.
Very shortly, on the efficient enforcement, I also like this question. In the AI Act, we really wanted to do everything to avoid sanctions, fines, and so on. So it was for us really this idea with regulatory sandboxes, but also what we see now with GDPR in Germany, for example, Baden-Württemberg, Bavaria, and so on, that companies proactively are going to data protection authorities, are saying, this is my product, what do you think, how do I become GDPR compliant as soon as possible, and so on. It was this whole idea of building up best practices, using network effects and so on, and cooperate as soon as possible in order to don't create any problems. If this is working, let's see. Again, it's depending a lot on the funding of regulatory sandboxes, also on the other mechanisms, and then, of course, if companies are also highly engaging in those structures. Right for an explanation and right for a complaint was being added as individual rights in the AI Act. It was the second question from the first group of questions, which is a bit problematic because product safety legislation doesn't really deal with individuals in this way. And again, going back to my point, NLF, so product safety legislation authorities, do not really have experience with protecting fundamental rights. We don't know how this is working out in the end. If, for example, what we hope, data protection authorities will be included if such a case is coming. But yeah, let's see. On the agency and FTC Khan question and so on, as I said already, at least in the parliament, and I know that D9 is looking very much into it, there's a lot of talk to centralize even more, then maybe create some entity outside of the European Commission, make it independent, and yeah, maybe install a charismatic leadership there similar to the US. But again, it depends on the new budget and on a lot of other things if there is really political will. But at least it's an idea that we maybe copy-paste something also from the United States. And on class action, I was also a bit surprised because other colleagues in DG Just are very much in a different direction. And indeed, we saw that basically in most digital legislations that was coming in this term, there's a reference to collective actions, class actions. And we are extremely curious how this is playing out. My boss, Axel Voss, and also myself, we were not really a fan of class action. We liked ombudsman systems more. But, well, now we have the decision, and there are more and more third-party litigation funders in Amsterdam, in Berlin, in London, with a lot of law firms. And we know that they are all waiting now, basically, of those laws becoming applicable, and then, collecting classes. And a Facebook case where maybe there's a small bias in the data set, you can easily bring together a lot of million people and make a huge class, which in the end, hopefully is not only very useful for the law firms and the funders, but also then for the end users that are suffering under this bias. But again, this is something in the future. Maybe last sentence from my side. Because we were so much afraid of the activities of third-party litigation funders, tabled an own initiative report as legal committee in the European Parliament, and it's now depending on the Commission to look more into it. They are now at the moment making a study with external professors, and the new college will basically inform us what the next steps are. So it's a huge topic for the next term, I think.
Thanks, Kai. Please, which questions do you want to address?
Well, mostly effective enforcement, because to me, effective enforcement is also, of course, solid decisions, but more importantly, it's those actions by supervisory authorities that drive compliance. If the end result is compliance, then the enforcement action is, in my opinion, effective. And we've talked about guidelines that can be effective in explaining how we interpret the law. We've talked about fines that have a deterrent effect. But between those two, there's an array of tools that regulators and enforcers can use that can be applied in certain situations. And in order to know which tool to use in what situation, you need to understand what drives compliance, but also importantly, what drives non-compliance. Just to give a short example, if non-compliance stems from not understanding the law, you need to apply a different tool than when non-compliance stems from economic reasons, understanding the law, but deliberately choosing not to adhere to it. So it all depends on the situation, and I'm really urging all my colleagues in this to look at their full toolbox and really choose what is effective in which situation, and it doesn't always need to be a formal instrument.
Yes, I want to also answer actually this question, but through the question on the guidelines. Because I do think that guidelines, depending on how you conceive their role, can be very important in actually achieving effective enforcement. Because I also did work with DPOs, interviewing them, and I got the same results. But the point is, can the guidelines help to then make sure that after the guidelines, we actually enforce what the guidelines say, to make sure that when a company or an organization get the guideline, reads in a more concrete way what they need to do, that they then also read it and they know, okay, this is what we really need to do, because otherwise, next week, next year, the authority will be on our doorstep. And I think that is what the role should be. And I think that also connects a bit to the question of the US. I haven't studied this in detail, so maybe I'm wrong, but I feel that there is more this idea of the FTC says we're going to interpret unfair commercial practice in this case in this way, and we're going to tell everyone this is how we're going to interpret it. And after we've told everyone that this is how we're going to interpret it, we're also going to then actually move up on that. I think that's what the role of guidelines should be, and that's why I think they ought to be and are very important. And I think also this comes back to what Eva said. I think once you have clear, concrete guidelines, then it becomes much clearer who wants to follow the law or who on purpose doesn't. Because when you have a lot of open norms, then indeed, especially small businesses can say, well, maybe we did it wrong, but we didn't really know that we were doing it wrong because we don't understand what we need to be doing. But once you go to a more concrete interpretation of the law and it's written down, then that argument kind of falls away. And then I think it becomes more self-evident almost who is following the law or is trying to follow the law and who is doing not mostly for profit-driven reasons or maybe for other reasons, especially when it's governments not following the law.
So thanks, everyone. I think we've kept this panel a wild mix of concrete and abstract. It's gone between legislative instruments without being very clear what it's talking about, but that's exactly what we were trying to achieve, because it's more of a vibe, effective enforcement, I think, in the end. The vibe across the digital signal market that we want to give out and to feel how we get these good vibes. And with that, I want to give the panel equal good vibes, and thanks them all for their time. Thank you.